The fine arrived certified, thick and smug. $70,000, itemized across 3 pages, for repeated violations, access interference, and something they called non-cooperative residency conduct. I laughed at first, not because it was funny, but because it was familiar. This HOA had been circling me for years, mistaking proximity for ownership and confidence for authority. This time, though, they decided to swing big. My property sits just beyond the formal boundary of their subdivision, a stretch of land that predates the HOA by nearly half a century. When the neighborhood was developed, the county approved a single-access road that cut through my parcel. The developers negotiated an easement, limited, specific, and recorded, to allow residents to pass through. What they didn't negotiate was control. The road itself never changed hands. It stayed mine, gravel, drainage, culverts, and all. At first, the HOA treated the easement like a leash. They sent notices about road appearance, demanded I resurface sections at my expense, and complained about a gate I installed for livestock control. I complied where the easement required access and ignored the rest. That balance annoyed them. HOAs prefer submission to compliance. The fine started small. $1,000 for obstruction. $5,000 for failure to maintain community access standards. Each notice referenced bylaws I'd never agreed to, covenants that never touched my deed. I replied with copies of the easement and my survey. They replied louder. Eventually, they bundled every accusation into one grand penalty, $70,000, meant to scare me into paying or selling. The letter threatened liens, collections, and restricted access remedies. That last phrase caught my attention. You can threaten access only if you control it. They didn't. I did. I drove the road that evening, slow and deliberate, noting the cracks they blamed on me, the drainage they never funded, the traffic volume that came entirely from their side. The easement allowed passage, not governance. Wear and tear wasn't my obligation. Maintenance was shared only where specified. Their fine assumed authority they never had, and worse, it documented that assumption in writing. The HOA board called an emergency meeting and invited me to resolve the matter amicably. Translation: pay up. I attended, sat through the accusations, and listened as they explained how my road served the community and therefore fell under their jurisdiction. I asked them to show me where. Silence followed. Someone pointed to a map printed from the internet. Someone else cited common sense. Common sense doesn't override recorded instruments. I told them I wouldn't pay the fine. I told them the road was mine. I told them the easement would continue exactly as written, no more, no less. Karen, the board president, smiled the way people do when they think they're about to teach a lesson. She warned me they'd escalate. She said the neighborhood depended on that road. That was the moment they gave away the ending. Because when someone fines you for a road they don't own and threatens remedies they can't enforce, they invite scrutiny. And scrutiny is dangerous when your authority exists only by habit. I left the meeting with their demands in my pocket and a plan forming that didn't involve arguments, appeals, or negotiations. It involved records. By morning, I'd pulled the original easement, the subdivision approvals, and the maintenance clauses everyone had ignored. By afternoon, I'd requested a compliance review from the county, routine, neutral, devastating when the facts are clean. The HOA didn't know it yet, but their $70,000 fine had triggered something far more expensive. They thought they were punishing me. They were about to learn what happens when you confuse access with ownership and fines with power. The county's response didn't come with sirens or speeches. It came the way real consequences usually do, by email, CC to people who suddenly wish they weren't included. A compliance review acknowledgement, polite and procedural, confirming receipt of my request and listing the documents under examination. The easement, the subdivision approval, the HOA's bylaws, and most importantly, the enforcement actions tied to the $70,000 fine. Karen didn't know about the review yet. The HOA, still confident, moved forward with collections. I received a notice from a third-party agency warning of liens and credit reporting. That move, aggressive and premature, would later matter. When organizations act beyond their authority, They tend to leave fingerprints. Residents started calling me quietly. Not confrontational, just confused. Are they really allowed to do this? One asked. Another admitted the board had mentioned temporary access pressure if I didn't comply. That phrase traveled fast. Threatening access when your entire neighborhood depends on a single road is less a strategy and more a confession. The county inspector arrived midweek. Clipboard, reflective vest, neutral expression, the holy trinity of credibility. We walked the road together. I showed him the culverts I'd installed at my expense, the grading I'd maintained, the sections the HOA claimed were neglected but which the easement never obligated me to upgrade. He photographed everything. Then he asked the question I'd been waiting for. Who's responsible for maintenance under the easement? I handed him the clause. It was clear, narrow, and unambiguous. Shared maintenance proportional to use, with no unilateral control by any association. The HOA had never paid a dime. They'd fined instead. That distinction matters. The inspector requested HOA records, maintenance logs, expenditures notices. The board scrambled. Emails flew. Karen called me twice and left messages that oscillated between stern and conciliatory. I didn't respond. This wasn't personal anymore. It was administrative. The most dangerous place for bluster is inside a file folder. By Friday, the county issued preliminary findings. Not conclusions, findings. Language like appears inconsistent, outside recorded authority, and potential misuse of enforcement mechanisms. The words landed like hail. The HOA was instructed to suspend all fines related to road access pending final review. $70,000 evaporated on paper. The neighborhood meeting that night was different from the last one. Less shouting, more note-taking. Residents asked why the HOA had never budgeted for road maintenance if it was community infrastructure. No one had a good answer. Karen tried to reframe, claimed the fines were meant to encourage compliance. With what? Silence followed. Then came the letter that changed the tone entirely. The county cited the HOA for exceeding its jurisdiction by attempting to regulate and penalize activity on non-HOA property. The citation included a warning. Continued enforcement could result in sanctions, including revocation of the HOA's standing to manage common interests related to access. That's when fear replaced confidence. The management company advised caution. The HOA's attorney, new, careful, recommended settlement. They proposed reducing the fine to zero in exchange for a cooperation agreement. I declined. Cooperation implies parity. There wasn't any. There was ownership and an easement, nothing more. Residents began to realize the leverage wasn't mine alone. If the HOA had overreached here, where else had it done so? People requested audits. Someone asked about the pool repairs that had been deferred for years while fines piled up. Another asked why reserve funds were thin. Power draws attention until it draws questions. Questions are expensive. Karen stopped smiling. The county scheduled a final hearing to determine corrective action. On the agenda, improper fines, unauthorized enforcement, and misrepresentation of authority regarding access infrastructure. The phrase "only road in" appeared in the memo. In plain language, the HOA had tried to strong-arm the one person it couldn't afford to antagonize. They had assumed dependence flowed one way. They were about to learn that when access runs across someone else's land, respect isn't optional, it's structural. The final hearing wasn't dramatic, and that was the point. Drama favors the unprepared. Records favor the patient. The county panel sat with binders open, tabs aligned, already familiar with the facts. Karen arrived early, quieter than usual, flanked by counsel who kept reminding her to answer only what was asked. The HOA's confidence had been replaced by choreography. The inspector summarized the findings. The HOA had levied fines on property it did not own, under bylaws that did not apply, citing standards it could not enforce. The easement was read into the record. Every clause, every limitation. When access is granted, it does not become governance. When use is allowed, it does not become control. Those distinctions aren't technical, they're foundational. Karen attempted one last reframing. She argued necessity. The community depended on the road. Without it, emergency access would be compromised. The panel listened, nodded, and then asked the question that ended the argument. Did the HOA ever negotiate ownership, purchase, or maintenance rights beyond the recorded easement? The answer was no. Necessity does not create title. Dependence does not create authority. The county's corrective order followed. All fines related to the road were voided. Collections activity was ordered to cease. The HOA was required to issue written retractions to affected parties and correct its public representations regarding jurisdiction. Most significantly, the panel imposed a condition. Any future attempt to regulate access infrastructure would require explicit, recorded authority approved by the county. Without it, enforcement would trigger sanctions. That condition changed everything. The road wasn't just mine. It was now a boundary the HOA couldn't cross without consequences. The management company withdrew. Their risk models don't like conditions. Vendors followed. Insurance flagged the HOA as high exposure. The board realized that the same road they'd tried to weaponize was now a liability they couldn't control. Residents spoke during public comment. Not angrily, precisely. They asked why fines had been prioritized over maintenance. Why threats replaced negotiation. Why the board had assumed ownership where none existed. Karen listened, eyes fixed on the table. Authority dissolves fastest when it has to explain itself. After the hearing, the HOA's attorney requested a private conversation. He proposed a global resolution, public acknowledgement of my ownership, a maintenance cost-sharing agreement consistent with the easement, and a formal apology letter to residents for the improper fines. I agreed to the first two and declined the third. Apologies are for people. Corrections are for records. We chose records. The road changed immediately. Signage came down. Notices disappeared. Maintenance discussions became collaborative instead of punitive. A shared schedule was posted for grading, with costs allocated exactly as the easement required. No fines. No threats. Just math. The ripple effects reached farther than the subdivision. Nearby associations asked the county for clarity on access rights. One discovered it didn't own a retention pond it had been fining residents over for years. Another paused enforcement pending review. The phrase "only road in" began appearing in compliance memos as a caution, not a claim. Karen resigned a month later. Not announced, just noted in the minutes. The board appointed a replacement with a background in civil engineering. Meetings shortened. Language softened. The HOA learned, belatedly, that stewardship works better than pressure. I drove the road that evening, slower than usual. Gravel settles when it's respected. So do communities. The fine that was meant to force me had instead forced the truth into daylight. Ownership clarified. Authority corrected. Access preserved. They fined me $70,000 because they thought I needed them. They learned the hard way that when the only road in belongs to someone else, cooperation isn't generosity, it's survival. Once the county's order took effect, the HOA entered a phase most organizations never planned for: compliance without leverage. It's an uncomfortable adjustment. For years, fines had been their language. Without them, they had to learn a new one: requests. That shift exposed how much of their governance had been habit rather than necessity. The board reissued communications, this time stripped of threats and deadlines. Notices became memos. Must turned into please. Residents noticed immediately. Attendance at meetings increased, not because people were afraid, but because they were curious. When authority softens, participation often grows. Financially, the impact was sobering. The HOA's budget had relied on penalty revenue far more than anyone admitted. With a $70,000 fine voided and others under review, reserves thinned. The treasurer presented a revised forecast that replaced enforcement income with actual contributions. The room went quiet. Reality doesn't negotiate. The road maintenance agreement became the model for everything else. Clear scope. Shared costs. Recorded terms. No improvisation. It worked. Potholes were filled on schedule. Drainage improved. Emergency vehicles confirmed continued access. The crisis that had been used to justify overreach dissolved once it was addressed honestly. Residents who'd once supported the fines began asking for refunds. The board commissioned an audit. It revealed years of inconsistent enforcement. Some properties fined aggressively, others ignored. Discretion without standards leaves patterns. Patterns invite scrutiny. The HOA published the findings. Transparency, once forced, became policy. Karen's absence changed the tone more than any rule change. Without a singular voice pushing boundaries, discussions stayed inside them. The new president opened meetings by reading the jurisdiction clause aloud. It was a reminder and a restraint. No one left. Everyone listened. I was invited to join a committee. I declined. Ownership doesn't require presence. Boundaries work best when they're quiet. Instead, I offered something simpler: copies of the easement, the county order, and a checklist for compliance. Tools outlast personalities. The neighborhood adjusted. Without constant notices, people handled small issues directly. A fallen branch got cleared by whoever had a saw. A parking dispute ended with chalk and a conversation. When someone suggested reinstating fines for edge cases, the idea died in the room. No one wanted to relive the review. The broader lesson took root. Access is not control. Service is not ownership. Proximity is not consent. These ideas sound obvious until they're tested. The test had been expensive for the HOA's pride, not the community's function. As summer rolled in, the road held up well. Traffic flowed. The shared maintenance fund balanced. The easement did its quiet work. What had once been a choke point became a line of cooperation, thin, precise, respected. People stopped asking me about the fine. They asked about the survey markers instead, about how to read plats, about recording agreements correctly. Knowledge replaced fear. That's how disputes end for good. By the time autumn arrived, the road had become what it always should have been: ordinary. No notices taped to posts. No warning letters. No emergency meetings. Just gravel, drainage, and traffic moving the way infrastructure is supposed to move when it's understood rather than argued over. The absence of conflict wasn't dramatic, but it was instructive. The HOA's final adjustment was cultural, not legal. They learned to plan instead of punish. Budgets were built on contributions instead of penalties. Projects were prioritized by need instead of leverage. When residents disagreed, they argued about outcomes, not authority. That change did more for the neighborhood than any fine ever had. The audit results were archived, publicly accessible, and, most importantly, used. Enforcement policies were rewritten to include jurisdiction checks as a first step. If a rule didn't attach to a deed, it didn't get enforced. Simple, effective, long overdue. The board stopped assuming and started verifying. That alone prevented future conflicts. I stayed out of meetings, but I didn't disappear. Ownership carries a responsibility to be reachable, not dominant. When maintenance questions came up, I answered them with documents, not opinions. When costs were shared, they were shared exactly as recorded. The easement became a reference point instead of a battleground. A year later, a fire marshal reviewed access routes countywide. Our road passed without comment. That mattered more than any apology. Safety had been used as a scare tactic before. Now it was addressed as a fact. Emergency access works best when it's planned, not politicized. The neighborhood gained something else too: confidence. People understood where their authority began and ended. They stopped deferring to volume and started trusting records. New residents were handed maps, not warnings. Questions were answered with citations, not assumptions. It turned out that clarity is contagious. Karen's $70,000 fine became a cautionary tale told without names. "Remember the road situation," someone would say, and that was enough. Overreach doesn't need to be relitigated if it's remembered correctly. The HOA didn't dissolve, but it matured. Sometimes survival looks like humility. From my side of the line, nothing changed, and that was the point. The land stayed quiet. The road stayed open. The easement did its work. Ownership isn't about exerting power. It's about defining limits and honoring them. Once everyone agreed on where those limits were, the tension vanished. People often ask if I felt vindicated. The honest answer is no. Vindication implies a contest. This wasn't a contest, it was a correction. The HOA fined me $70,000 because they thought access meant control. They learned carefully, publicly, and permanently that it doesn't. If there's a final takeaway, it's this. Infrastructure creates dependence, but dependence does not create authority. Roads connect communities, but ownership defines who decides. When those lines blur, conflict follows. When they're respected, everything else gets easier. The only road in remained exactly that, the only road in. But it was no longer a threat or a bargaining chip. It was just a road, doing what roads do best when people stop fighting over them. And that's how a $70,000 fine turned into a lesson everyone could drive on.